The basic structure of a trust is, it's an agreement, really, kind of like a contract between the trustor, or also called the grantor, the person creating the trust, and the trustee, the person managing the trust and the trust assets, what's held by the trust, for the benefit of the beneficiary or beneficiaries that are named in the trust. So there are many different types of trusts. They're revocable, like revocable living trusts. There are also irrevocable trusts, like life insurance trusts or real estate trusts or family trusts, things like that. The most common trust is a living trust or a revocable living trust. And by revocable, I mean it can be revoked, it can be changed, it can be modified, as long as the person has testamentary capacity to make those changes. If you're creating a revocable living trust, it means you're also creating a will. And the will may be called a pour-over will, meaning the assets pour over into the trust. But it's really the will referencing the trust that gives life to the trust. So you need both. But what a trust can do, a revocable living trust, if properly funded, it can help avoid probate. And a lot of people want to avoid probate because probate's a public proceeding. Probate can mean there's more time consumed and more costs involved. Whereas maybe you think, if I invest now in having a trust created, then I avoid probate and the costs associated with probate and all the stressors that family members have when they're trying to administer your estate when you die. And another big difference is when you have a trust that's properly funded, you don't need to have your trustee formally appointed by the court. There's a smooth transition, and that can be during periods of disability or incapacity, but also when you pass. So a trustee is someone who's in charge of the trust and managing the trust assets. So taking care of expenses and monitoring income that comes in to the trust and all of the assets of the trust. So a trustee should be someone you name who you trust. It should be someone you know to be able to act as a fiduciary, meaning they represent your interests, not their own, and the interests of the beneficiaries you name, and also the terms of the trust. They honor the terms of the trust. And good idea to name someone who's prudent financially and would make wise financial decisions as you would make about your own estate. You want them to step into your shoes and make those decisions for you when you're either incapacitated, disabled, you can't make those decisions, or you've passed away. For more information about trusts, the different types of trust, will versus revocable living trust, tips on avoiding probate, and your estate plan, contact us at clearwaterpnw.com and ask for a free case evaluation.